please the court, Mark Tinker on behalf of May Moody. I'll say that I'll reserve 5 minutes, but I'd be surprised if we use all of our time today because this is a relatively simple issue. During trial, the judge said we're going to handle the issue of PIP set-offs post-trial. We get to post-trial, and he says, well, in the interim, I've read this case that says we're supposed to do it during trial, so I'm not going to give you the set-offs anymore. And the only thing that I'd like to say, other than what's been presented in the briefs, is I just want to make sure that we're clear on how this issue arose during trial. Moody's trial counsel, during the middle of his case, said, well, Judge, I thought we had an agreement that this was going to be done post-trial. Now I'm starting to understand that might not be the case, so can we kind of, figure out what we're going to do here, because otherwise I'm going to need to present the evidence to the jury. The judge said, well, you know what, I think this is normally handled post-trial. Is there any dispute as to what the amount of the set-off would be or what the PIP was paid? Both counsel said, no, there's no dispute, and the judge said, well, that's fine, we're doing it post-trial then. So this wasn't something that necessarily Moody's counsel asked for or invited. He said, Judge, I think we're not clear. I need to know if I need to put my evidence on. What are we doing here? And the judge said, we're doing it post-trial. So
Who prepared the verdict form?
the verdict form, as I understand it, was prepared by Dorset's counsel, as were the jury instructions.
So, and there wasn't any space in the verdict form for PIP set-off, was there?
There was not, and the judge noted that during trial. He said,
wouldn't
well,
that be consistent with doing it post-trial?
I believe so, and that's what the judge looked at during trial. He said, well, I've got this verdict form that doesn't have a space for the jury to consider that. That's something that we normally handle post-trial, so that's how we're going to do it here.
Was there a stipulation pre-trial?
As I understand it, there was not. I can tell you that there certainly isn't one in the record.
At the time the judge at trial, did both counsel agree to doing it that way?
No.
In fact,
Dorset's
one attorney
counsel
says, we never stipulated. I told you it was wrong to begin with. I still object. And the judge says, well, that's where we're going to do it. And he says, I object, but we understand.
Absolutely. And I think
I thought the law suggests that unless there's a stipulation, it has to be done at trial.
That is the law, but at the same time, we've got Moody's counsel, the man wearing the robe says this is what we're going to do.
He says
That's
that,
what he's supposed to do.
because he's asked by defense attorney, and the other side says, we don't agree. The law is the law. Let me ask you, there was something done pre-trial, some type of hearing, motion, discussion, that's not in our record.
There was just it's not a hearing, it was just as I understand from what was in the transcript that we've got, there was a conversation, correct.
And the one attorney represents that he never agreed.
Correct.
So he says, I've never agreed, I don't agree now, I didn't stipulate, I don't stipulate, and I object.
Absolutely. And the issue, I think...
Why doesn't that trigger the case law that says if you don't have a stipulation, it's got to be done at trial?
Because the judge made a ruling, and Dorset's trial counsel
The judge was wrong, and he made the ruling at the invitation of somebody who was also wrong. Having been put on notice that he's wrong, he still makes the invitation, and the judge rules. Why isn't that an invited error?
Because I think there's two cases, the Sheffield case out of the Supreme Court, and there's a supplemental authority I just filed, and I forget what the name of it is. There's a workers' compensation case out of the 1st District. Both of those looked at what a judge did and said, the judge was in error, that was a mistake, but at the same time you're entitled as a litigant to rely on what the judge tells you to do. And so here, even if we all agree that, the Supreme Court says this is supposed to be done by the jury, we all agree in the absence of a stipulation, the judge was wrong, but the judge told Moody's counsel, this is what we're going to do, and you're entitled to rely on what the judge tells you to do.
And he did that because he was asked to do that by the other side.
He was not asked to do that, it was asked for a clarification of how we're going to do it.
Well, I think the language was he came in and said, Judge, I thought we were going to do it this way, but I understand he objects, and the judge says, well, if there's no difference as to opinion, there's no difference as to whether it was paid and how much was paid, we'll just do it post-trial. Why isn't that in response to the invitation?
It was a question of how are we going to do it, because this is the way we usually do it, Judge, but I understand he's now objecting.
Not only the way we usually do it, but this is what the law says.
Correct.
What the courts have said, the law says this is the way you do it. And the courts have said the parties can stipulate to waive the law, but absent that stipulation, this is the way it has to be done.
That is what the case says, but at the same time, if the judge, even if he's in error, if he says in the middle of trial, this evidence is coming in, that objection is overruled, parties are entitled to rely on
Put you
that.
on notice and say, Judge, you're wrong. Even if the judge even the attorney puts the other attorney on notice saying he's wrong, that's not what the law is.
Well, that's going to be any time during trial where there's an objection and there's somebody saying, Judge, he can't put that witness on. Yes, I can. No, I can't. I mean, somebody's telling the judge that the other side is wrong. They both
So
are.
nobody gets to appeal because we've got to rely upon what the judge told them. Everybody gets to proceed with what the judge told them, and we can't reverse it.
Well, I don't
There's
think
no
that-
appeals.
I don't think that follows what it is. I mean, there's even I don't know if it's a procedural rule or statute on it now that says if a judge gives you a definitive ruling on the record, you don't need to persist with objections and keep trying to tell the judge he's wrong. You're entitled to do what the judge tells you to do and then go try and fix it afterwards on appeal.
Mr. Tinker, let's suppose that opposing counsel is correct and the judge's ruling was wrong, and the defense should have put in the evidence about the PIP Setoff during the trial and let the jury decide. What's the appropriate relief then? Do we send the case back and let the parties try it over and let you put the evidence in and let the jury rule on it, or is the point just gone forever?
I think the relief would just be to apply the set-off. I think it'd be a tremendous waste of judicial resources to retry the case and put in evidence when we all agree we know what the set-off is.
Assuming that doesn't, you're wrong, and you shouldn't have relied on that, and you shouldn't put the evidence in, but you relied on it to your detriment. So what's the appropriate relief? The retrial?
I think it's just to apply the set-off, because that's what the judge said we're going to do. There's no dispute as to what the amount is. It's $5,500 and change.
You're assuming in my hypothetical that that's impossible now because it was supposed to, opposing counsel objected, and you were obligated to put the evidence in at the trial and let the jury make a ruling on it and note it on the verdict. So why shouldn't there be if that's the case then, why shouldn't there be a new trial?
Well, I think two things. Nobody has asked for that relief. They didn't ask for a new trial or say that any other element of the verdict or anything else was improper that was done there. The only thing that we're talking about is we all know what the set-off is. Does the jury do it? Or, I mean, there's no dispute as to the amount. There's no dispute as entitlement to it. It's just procedurally how it was done.
Dispute about the jury having to rule on it.
Well, that's just procedurally how it's done. Does the jury put it on the verdict form, or does the judge do it post-trial? And the Supreme Court has said, with these stipulations, you can do it post-trial if everybody agrees to what the amount is.
Everybody didn't agree.
Everybody didn't agree procedurally how to do it. As far as the substance of it, what the amount is, there's nothing for the jury to figure out. I mean, the statute says you're entitled to a set-off. Everybody knows the amount.
So the judge could, on his own hook, just say, this is the way we're going to do it. I don't care what the case law, what the law says. This is the way we're going to do it, and everybody's going to do it this way.
I'm not sure that the judge can, and I don't disagree that the judge made a mistake in this case, but the question is counsel and the litigant entitled to rely if the judge says, we're doing it post-trial?
Is counsel entitled to rely when he asks the judge to make a mistake?
He didn't ask the judge to make a mistake. He said,
He's
Judge,
the one that suggested it.
He said, I thought we had an agreement. I'm now understanding that might not be the case. I want to just clear up, do I need to put this in? And the judge said, well, there's no space for it on the verdict form. Everybody agrees to what the amount is, so we're doing it post-trial. And I understand that there's objection, and I agree with counsel and with the court's apparent opinion that that was wrong. That's the Supreme Court says you're not supposed to do it that way. But the judge said
He thought there had been some agreement.
Because I think both Moody's counsel and the judge thought there was agreement until all of a sudden it arose, well, wait a minute, no, there was not.
And the error was when the judge realized there wasn't, he didn't understand the law to say that he couldn't proceed.
I agree. And I think that was a mistake, but the judge said, this is how we're going to do it. And the question is, counsel is supposed to go against what the judge just told you he's going to do? Or is he entitled to rely on that? And then come to find out post-trial, the judge says, well, in the meantime, I've read this case, and so we can't do it this way, despite the fact that I told you that's what we're going to do.
And there is no contention that counsel was not aware of the requirements of the law, that you have to have a stipulation.
I don't believe there's anything in the record that shows one way or the other. I know that the case that says that there's a stipulation, needs to be a stipulation, was not argued during trial. This was I mean, you've seen the transcript. It was a very quick discussion that just happened at a sidebar. But, I mean, the issue is, and again, I can't disagree, the judge got it wrong. But the question is, he told the parties, this is what I'm going to do. There's no space in the verdict form for it. This is what I'm going to do in this case. So can counsel rely on that, or is it supposed to go against what the judge just told him that he's going to do? And I think for that reason, you know, if the judge says we're doing it post-trial, then I think that counsel is entitled to rely on that and is entitled to the post-trial set-off. I'll just reserve my time. Thank you.
Okay, thank you.
Please, the court.
Sure.
Thank you. Good morning. My name's Philip Slotnick, and I am representing Mr. Dorsett, the appellee in this matter. It's a pretty short, straightforward issue, I believe. I was also the trial counsel in this case, so I'll try to stick to the record and not, you know, going beyond the record from what I know. There was never any stipulation, which there needs to be. There needs to be a stipulation, and in writing for that matter, if we're going to do this PIP offset post-trial. There was never such agreement ever at any time. So when I think counsel for Moody realized that they never did this stipulation, which they, I assume, normally do or look for, he asked Dorsett's counsel for a stipulation at trial, and Dorsett's counsel said, no, I will not agree to that. That's when Moody's counsel invited the judge to make the error to handle this post-trial. Dorsett's counsel objected and stated that the law is you have to prove it absent a stipulation. And as we know, without saying this ad nauseam, Moody's counsel never presented any evidence. And I think what defense counsel or what counsel for Moody should have done, because they have to have known this law, this is what their practice is, what they should have done if they had the evidence is proffer the PIP log to the judge outside the presence of the jury. There were proffers done by Moody's counsel throughout the trial, so they know that it exists and they did it during the trial. They never did it with the PIP log because it's our contention they never even had it, which is why it was never specifically listed in their exhibit list. Or they could have proved PIP payments through a PIP.
I don't understand why any trial attorney would do what you're suggesting in the face of a very clear ruling from the trial judge. He says, I think it should be post-verdict. I mean, wouldn't it just antagonize and irritate and annoy the trial judge that you're wasting his time putting in this evidence or proffering it when he'd said, counsel, I've already ruled on that. What are you doing?
And I think that's a fair statement that you make. I think that the Moody's counsel should have known and must have known that the law was against them. And therefore they were trying to figure a way out of the box they put themselves in, hoping it would never reach this point. But Moody's counsel should have known they were wrong, and when the judge, to all of our surprise, or at least to Dorsett's counsel's surprise, ruled that way, I think the proper procedure would have been for Moody's counsel to say, Judge, I appreciate your ruling, but just to be on the safe side, I just want to proffer this anyway, because I have it right here, and this would take a minute, if that were the case. So I think you're right. It does have that possibility of antagonizing the judge in a favorable ruling, but I also think it would have been the smart and proper thing to do to just proffer it anyway if you had it, just to cover your bases. And then they also, of course, they could prove it one of two ways, through a PIP log or through a PIP adjuster. But they never had a PIP adjuster specifically listed on their witness list, although in fairness, Dorsett's counsel had listed a representative of the PIP company, and Moody's counsel on their witness list wrote down or listed all witnesses listed by Dorsett's counsel. Having said that, they never did specifically list a PIP adjuster on their witness list. There's never any subpoena to a PIP adjuster for trial. And I think most importantly, when Moody's counsel listed their witnesses to the jury at the beginning of the trial to make sure there's no conflicts or crossovers between jurors and witnesses, they never listed a PIP adjuster. They had no intention of presenting this PIP evidence at all.
If you're correct, Why shouldn't the relief, and they relied on this ruling by the judge, why shouldn't the appropriate relief be to send it back for a new trial and let the jury determine the question, and if
Sure.
that's what's necessary?
I think that would be the case if it was an invited error. I think that if both sides made a mistake and told the judge to do this and the judge was wrong, then I would agree that would be the proper remedy. I think the situation here is one of invited error, and I know I've read cases where the courts discussed that, and I want to get the quote as close as I can to be correct. When a trial lawyer leads a judge into an obvious error, cries of harmless error on appeal are likely to fall on deaf ears. I think that your remedy would be correct if it was a joint error, but not with an invited error. Are there any other questions? Thank you. Appreciate it.
Just briefly to address that last point, I don't believe that this is a situation of invited error, and that's what the cases I discussed talk about. When the judge makes a ruling, I know Sheffield was one where a litigant said, "Judge, I think you need to exclude this witness's testimony." The judge says, "No, it's going to come in." So that party turns around and calls the witness and puts him on the stand, and then later on appeals and says that shouldn't have come in, and there's a claim, invited error. You're the one that put the witness on the stand, and the Florida Supreme Court said, no, not if the judge has made a ruling. You're entitled to try and minimize the damage to conduct your case in accordance with what the judge told you he's going to do. And that's what we have here, is the judge says, we're going to do it post-trial, so litigants are entitled to rely on that and don't go off doing other things, just going to do it
The whole
right.
conversation started off with counsel saying, "Judge, I was wondering if we could do this post-trial."
Because he said, I thought we had an agreement, and the judge said, I thought you did too. And, I mean, that's the first thing out of the judge's mouth, is I thought you did too.
And then the other side said, "No, we never agreed. I don't agree now, we never agreed, I don't agree now, and I object."
Correct, and Moody's counsel was saying, "Judge, I need to know what we are going to do, because if there is no agreement, I'm going to need to do this." And the judge says, "No, there's no space on the verdict form for it. We're doing it post-trial."
Did he offer to do it, or just say, "Can we do it post-trial"?
The judge interrupted his sentence, actually, because the jury came into the courtroom, but he said, "Judge, I need to know what we're going to do, because otherwise I'm going to need to," or something like that. And the judge cut him off and said, "I thought we were doing this post-trial." He said, "I did too." But that was the start of saying, otherwise, if there's no agreement, I'm going to need to. He was saying, I'm going to have to prove this in front of the jury. And the judge said, there was that quick discussion. The judge said, no space in the verdict form, we're doing it after. So at that point, I mean, counsel's entitled to rely on that. And like I said, I think it's a pretty straightforward issue, unless you have any other questions. Thank you for your time.
Very good, thank you. Thank you both.
Thank you.